Good afternoon. I'm a senior investigative reporter. I am joined today again by Mike Howard, who will be our legal analyst for this afternoon. We're waiting for a hearing that's going to start at 1:30 this afternoon. This is a hearing, and I want to kind of recap how we got here because this hearing is really important and it potentially could lead to a mistrial. Really quickly, what we saw was a teacher was on the stand and she was describing what she saw and heard. And really importantly, she described seeing a man in black carrying a rifle on the south side of the school. Okay, that's important because the defense has argued that Adrian Gonzales, the former Uvalde schools officer, could not have had line of sight of the shooter. And so by her description of that calls into question the defense's argument. It came out in court that she had not said that originally when the Texas Rangers interviewed her 4 years ago. And then it came out that the prosecutors had interviewed her shortly before the trial and that they had not disclosed those notes to the defense. And that is the issue that is at play today, and we are waiting to see what this judge will decide. And now I'm going to take us over to Rebecca Lopez, our senior crime and justice reporter who is down in Corpus Christi. Rebecca, what's the scene there today?
Well, we're obviously just waiting for the hearing to start. But last night, after our live coverage, we did in fact have. Oh, thank you. I'm sorry, somebody's handing me a media pass. We did in fact have. The defense attorneys come out and speak. So they, Nika LaHood, who's the lead defense attorney, came out and spoke and said, look, we believe that there might have been a Brady violation or a violation of the Michael Morton Act, which is here in Texas. So he says, look, they should have turned over this exculpatory evidence. And we believe that they knew how she was going to testify since December of 2025. And so they said they should have turned it over to the defense, and prosecutors obviously say didn't. And in fact, we did a little story for the 10 o'clock news, and we're going to toss to that piece right now because we do hear Nico and the other defense attorneys talking about what happened in the courtroom. So let's go to that story right now, Tanya.
On the first day of testimony, jurors were walked step by step through the moments when gunfire broke out outside Robb Elementary. Jurors heard that emotional 911 call from a pastor who told the court he watched the gunman crash near the funeral home, then began shooting outside the school as he walked towards the campus. But it was the final witness of the day who shifted the direction of the trial and set off a tense exchange in court. A teacher testified she saw the man dressed in black carrying a long rifle on the south end of the school, a detail prosecutors acknowledged she had never previously reported publicly.
You understand how we would be surprised that she testified that she saw him.
Defense attorneys say the testimony places Gonzales in the same area as the shooter, directly conflicting with where they say he was during the attack.
So that would be an important thing for us to know before we started this trial.
Defense attorneys pressed prosecutors arguing the witnesses may have shared that information months ago and questioned why it was not turned over before trial.
Had you ever heard her say that she had seen him either going into the south side of the building or approaching the south door?
No. Prosecutors responded that the statement was never formally documented and did not stand out at the time.
When we were prepping these witnesses, I was running a law office, and so I was in and out of interviews. So I can't say that she said that and I like, oh my God. You know, it wasn't that type of reaction for me. So that's the best I can say.
Defense attorney Nika LaHood said the defense believes prosecutors were aware of the statement as early as December and that failing to disclose it is serious.
Then the problem that's more troubling is the fact that she told them in December, and they've acknowledged that.
Do you think
and they didn't turn that over.
This trial is something the victims' families have been waiting for a long time. The latest developments have left the families concerned and worried that justice might be delayed.
Well, Rebecca,
the families are. Oh, I'm sorry. Go ahead, Tanya.
Well, Rebecca, I obviously we heard the prosecutor say that, well, they didn't think it was that big a deal. But that's the whole idea of the Michael Morton Act, is it's not up to the prosecutors to decide what's important. But last night you texted me, and I was a little shocked at what you texted me, that the judge in this case oversaw the Michael Morton exoneration. Talk to me about that and what you found out.
Yeah, Sid Harrell was the judge back then that basically was the one who ruled on the exoneration of Michael Morton after listening to all of the evidence. And for people that don't know, Michael Morton was a man who was convicted of killing his wife, and he spent more than 20 years in prison. But DNA eventually clears him. And here's the thing. Apparently, the prosecutors had evidence that would have cleared Michael Morton. That's exculpatory evidence, and that evidence has to be turned over to the defense. Anything that could help the defense has to be turned over to them by the prosecutors. And in the Michael Morton, that did not happen. So now it is law. You have to turn that over. Anything that might help the defense in exculpatory evidence that could lead to the exoneration or a not guilty plea for the defendant has to be turned over. And it's very interesting that Sid Harrell, because I'll tell you, his demeanor in court, to me, he seemed very, very concerned. And the fact that he called this special hearing today and then told that witness, the teacher, to come back tomorrow at 9 o'clock, I think is very significant, because he obviously knows this very well and has a close relationship to what happened with Michael Morton. Tanya.
Yeah, I agree. And I think this judge, just given his background, is going to take a whole different view of this. And maybe if we had a different judge who didn't have a very personal connection with how these sorts of things can play out when prosecutors do not follow their duty to turn over exculpatory evidence. And so, I don't know. Obviously, I've been talking to Mike about it. We have no idea how this is going to turn out.
Well, I will tell you, the families are very concerned. In the courtroom yesterday, they were like holding their heads. They're upset. They're actually doing a couple of interviews right now. They're worried. And obviously, Adrian Gonzales' team had to go back last night and talk to him, his defense team, to see what do they want to do. What does he want to do? Do they want to push for a mistrial and then have to impanel a whole new jury and wait months, possibly years, to retry this case? Or do they want to continue to proceed and maybe have the witness excluded or testimony excluded? But, you can't unring that bell. This all played out in front of the jury. The jury was inside the courtroom when there was this back and forth that you just saw between the prosecutor and the defense. So that bell's been rung. I don't know how you unring it and the jury doesn't unsee it. So it will be interesting to see what they have decided. I felt like once we interviewed the defense attorneys last night that they are going to push for a mistrial, Tanya.
Yeah, I kind of think that too. And you're right. And the jury, they only know what happened in front of them. They don't know about all the stuff that took place outside their presence. They didn't see the prosecutor get questioned under oath. And I mean, I don't know about you, but we talked about this yesterday. That's a really unusual thing for the prosecutor to be put under oath.
I thought that was really unusual. And the fact that the assistant or the special prosecutor on the same side is also questioning her. Tanya, I have never seen that in my career. And I've actually never seen something like this play out in court. It's very significant. And again, this judge took this very serious, and he says that on the stand. He says, but he said that on the bench. He's like, look, this is a very serious matter. We're going to have to listen to witnesses, and we're going to have to hear both sides, and we're going to let this play out and see what happens. So, Tanya, it'll depends. I don't know what's going to happen.
I don't either, and we'll be very interested to see how this plays out this afternoon, and whether or not it's unclear if we'll get a ruling today either.
It feels like he's probably not going to rule on it until tomorrow, since he asked that witness to come back at 9 o'clock, but I don't know. And also, maybe you guys can answer this question. Do you think that the defense may have known about the fact that this judge was the one that ruled in the Michael Morton case, and they also, may have been looking for that opening for their client to get maybe a mistrial or some of the evidence tossed out?
It's certainly possible.
I'd ask your expert that.
Yeah, it's certainly possible Sid Harrell is well known. He is the presiding judge over the 4th Administrative Judicial Region, which is the entire region down there. And so he is a very well-known figure. And so I would think that pretty much everybody down there knows of his role in Morton. And I doubt that they were explicitly thinking that going into the trial, but I have to think when they see a potential Brady-Michael Morton violation, ironically happening in front of the very man who presided over the Michael Morton case and was so instrumental in the change of the law to open up discovery, that they knew how serious this was and how seriously he would likely take it.
And Mike was doing a little bit of research on the law, Rebecca, that I think you'll find interesting. Can you talk a little bit about what you found when you were looking at the law?
Yeah, so, it was interesting because yesterday when the prosecutor was under oath testifying, she tried to argue through the cross-examination that, well, it's not our fault. We made our files available. We opened up our files and you just didn't come over and look at them. And what's interesting about that is the Michael Morton Act says that for general discovery, it's okay for the state has to produce it or permit its inspection. So them opening their file and saying, come to my office and you can inspect whatever you want, that satisfies Michael Morton generally. But when it comes to exculpatory evidence, which this undeniably is, when it comes to exculpatory evidence, just permitting inspection isn't enough. They actually, it says, shall disclose, shall produce exculpatory evidence. So produce is a lot different than permit inspection. So when she was arguing in front of the very judge who I'm sure knows the Michael Morton Act backwards and forwards, she was arguing something that is explicitly against what the Michael Morton Act says. I'm going to guess he caught that.
I think so too, and I think it's very important.
And Tanya, I want to jump in here real quickly because I also found it interesting. The defense is basically saying, I'm sorry, somebody's trying to walk by me real quickly. The defense is telling, I'm sorry, I lost my train of thought here. Come back to me in a second.
Okay, it's okay.
Yeah, trying to get around people. It's obviously it's a very busy courthouse. Oh no, what I was going to say is the defense also says, look, this witness testified exactly the case that we presented earlier in opening statements. We said that part of our defense is going to be that he was on the other side. Adrian Gonzales was on the north side, so there's no way that he could have seen the shooter on the south side, and there were no witnesses that could put him there. And so when the fact that this witness then came out and said, oh yeah, I saw him years later, when did she change her story? I don't know, but they definitely were suspicious of the fact that they had said that in opening statements, and then all of a sudden now they have a witness that says, oh yeah, I saw him on the other side of the building.
Well, I'll be very interested to see how this hearing shakes out this afternoon. Rebecca, we're going to let you go because I know you got to go get in the courtroom. So.
Yes, I just got a court pass, so I'm going to go in there and see how the family's reacting and what's happening. So I'll let you guys. I'll come back to you guys later.
Thank you. All right, Mike. I don't know.
This is certainly interesting. So for those of you who are hearing all these words thrown out, Brady, Michael Morton, let me give a little bit of a deeper dive. So since 1963, we have had the law of the land in the entire United States is what's called Brady. So Brady versus Maryland was a case that went before the Supreme Court, and that said that the prosecution must turn over exculpatory evidence. Texas did not have a specific law on the books that made that part of state law as well. And so that didn't happen until Michael Morton. And so Michael Morton, I think, was acquitted and had his conviction overturned in 2011, and then 2013 is when the law changed. And so when we hear about Brady, Michael Morton, it is shorthand for saying that the state has to produce exculpatory evidence. And exculpatory evidence doesn't just mean it clears his name. It by itself means he's not guilty or he's innocent. Exculpatory, the definition, let me get this right, the definition is anything that tends to negate guilt or reduce punishment. So even if it's just a little bit, so a change in a witness that might affect their credibility, the fact that somebody is on this side versus on that side, when it would either make it possible or impossible for him to have a line of sight, all of these things make it arguably exculpatory. And so then, under Michael Morton, the prosecution has that kind of affirmative duty. They can't just say, come and get the evidence when you want. They actually have to produce that to the defense.
Yeah, and given this judge's background, this becomes really important. Okay, so just in case you are just joining us, we're going to give you another quick recap. We have a hearing starting at 1:30. We had a witness who testified, a teacher who testified that she saw the shooter on the south side of the building, and that's really important because the defense's contention is that Adrian Gonzales could not have seen the shooter, that he did not have line of sight on him prior to him entering the building, okay? And this teacher had given she didn't mention that in her original statement to the Texas Rangers, and that could be for a lot of reasons. I'm certainly not going to accuse her of lying or anything like that. Memory is a really funny thing. She could have forgotten to mention it. She could have watched so much coverage over the years that her mind now thinks she saw that. It's really hard to say. And so we think our minds are photographic, but they're not. Memory just doesn't work like that, and we've seen that in all kinds of ways with eyewitness identifications and that sort of thing. Anyway, she had given a statement. She was being interviewed by the prosecution shortly before the trial started, and she had mentioned this issue, and they did not disclose it to the defense, and they acknowledged that. And so what Mike is saying is the law says they have to affirmatively disclose it. It's not just we opened our files, it's we gave it to the defense. And as Rebecca learned last night, the judge in this case oversaw the Michael Morton case, and that is a hugely important case in Texas because it was a sea change in how we treated these cases. But prior to Michael Morton, the perspective of DA's offices was, we'll just turn it over if we feel like it, right?
Right. Yeah, the general attitude was we don't have to. Texas law doesn't make us, and so we don't. I gave this anecdote yesterday that in my very first case, when I defended a murder case that was ultimately dismissed because my client wasn't there, but that he was charged with murder. When I got discovery in that case, it was like roughly 20 or 30 pages, most of which was just redacted. It was just black boxes where they had marked out all the information. And I mean, I essentially had 2 or 3 pages worth of useful information. That was kind of the old days in Texas, very much trial by ambush. The Michael Morton Act was a huge change. And it's interesting to me, not just ironic that Judge Harrell presided over that and is now presiding over this, but I think what's especially interesting is that he not only presided over that case, he was instrumental in holding that prosecutor who withheld that evidence back in the Michael Morton case accountable. He asked for an inquiry into prosecutorial misconduct for that prosecutor, Kim Anderson, for withholding evidence, and ultimately that inquiry led to him losing his license, being disbarred, and being held accountable. He actually served 10 days in jail.
That's a big deal.
For that, which is the only time in I think U.S. history, definitely Texas history, that a prosecutor has served jail time for misconduct. So, I think we don't know. We've said this 1,000 times. We don't know what Judge Harrell is going to do ultimately, but the fact that he has held prosecutors in a high-stakes case accountable for misconduct before means that he is serious and he means business. So I think that is extremely interesting, especially when we have a situation where the open question is, did they withhold exculpatory evidence? And that's exactly what he found before.
Exactly. As you can see, we've got a live shot up of the courtroom right now. We saw family members file in a short time ago, and there's the prosecution team, the special prosecutors that are overseeing this case, and the female prosecutor that I don't think I caught her name.
Yeah, I didn't catch
but
her
anyway,
name either.
she was the one that testified that well, we opened the files up, and we told the defense they could come over and take a look at it, and as Mike has explained, that's just not good enough for exculpatory evidence. They have an affirmative duty to disclose that, and you can just tell by the looks on these family members that this has been I can't even imagine how these people feel. I mean, you lose your children under horrific circumstances, and then it's taken you 4 years to get somebody in a courtroom. Okay, we can see a little bit of movement in here. People are standing up. That means the judge has entered the room is when they start standing up like that. But the hearing's not slated to start until 1:30. The jury is not here today, and of course the reason for that is this special hearing. This is outside their presence. We heard the judge admonish them yesterday, do not, under any circumstances, watch, talk to anybody, listen, and that would be really hard.
Yeah, and I don't mean to put the cart in front of the horse, but if a mistrial is not granted and this trial goes forward, I guarantee the very first thing the defense is going to want to do, and frankly probably the judge and everybody's going to want to do, is ask those jurors. They'll probably ask them one by one, did you watch any media coverage? Did anyone mention to you what's going on? Because, as you said, these are human beings. It's going to be extremely hard not to Google it. They've all got to be so curious as to what in the world just happened. And
why did we get sent home?
Right.
What's happening?
And so, it would be very normal human behavior against the rules, but very normal human behavior for them to go look into it. And if they did, that in and of itself could cause a mistrial.
Right.
And so, it is a thorny situation. Ultimately, the judge has a lot of power in this. He can declare a mistrial. He can say that was a violation of Brady and Michael Morton, and I find that impacts the ability to have a fair trial, and therefore I declare a mistrial, and this is over. Or he can, under a change in the law that happened just last year, they now can exclude evidence for an untimely Michael Morton disclosure. So if the judge finds you should have disclosed it, you didn't, it came out way too late, but I'm not going to declare a mistrial, he could say, I'm going to exclude that evidence. And so in this case, that would be the testimony of that witness, of the teacher we already heard. The problem with that is, of course, as Rebecca said, that bell's been rung.
Yeah, how do you unring it?
You don't. You don't. And
they still heard it.
Exactly. They heard it, and I think the defense would argue very aggressively against that because, understandably, how do you unhear something you already heard? But we do have that mechanism in law. It's a little bit of a farce, but the judge says, I order you to disregard that testimony.
And they're not going to really completely understand why it was, because again, all the stuff about the prosecutor being put under oath and all that happens outside their presence.
They don't know this wasn't disclosed. They don't know that there's anything wrong with that. They just know they heard her say one thing, then the defense said, wait a minute, you never said that before. So that's got to be interesting. And then all of a sudden, all this rush out the courtroom, hush hush. So, but the other issue with that is the defense would be able to argue, look, Judge, this was extremely compelling testimony. Prior to this all coming out that she had never said this before, you and I were commenting about how her testimony was like a dagger to the heart. I mean, she, talking about getting the kids into the room before she got herself safe, talking about grabbing a pair of scissors, making a plan to defend them.
And the little kids getting the safety scissors? I was just like,
It was so visceral and real and heartfelt. And then just thinking about this is a woman who's devoted her life to teaching kids, and then she has had to leave the profession of teaching, I'm going to guess because of this horrific tragedy. So, her testimony was extremely compelling. And so it's already hard to unhear testimony, but let's be honest, there's no way to unhear her testimony. This was not just some boring, bland, chemical analysis, scientific testimony that no one cares about. This was very compelling, heartfelt testimony. So, yeah.
Yeah, I don't know how you unring the bell. You and I were talking before we went live about, what's the likelihood that they might, if you were laying odds.
Yeah, I tell my clients this. I hate being asked this question because I'm just making up numbers, but, I 50-50. This is really, normally, when somebody's asking, when I move for mistrial because something's happened in one of my trials, I know in my heart that it's a long shot. I know in my heart.
You're doing it for the appellate record.
I'm doing it because I have to. I'm doing it for the record. I'm doing it because it's my job. But I understand when I'm doing it that my chances are 10%, 5%. They're not good. In this case, when I say 50-50, that's significant. That's shockingly high. And maybe 60-40, in the favor of mistrial. I think it's going to come down to I assume we're going to hear more testimony, more evidence about what was heard, what was said. The problem they have though is just in the little part we reheard earlier from when the female prosecutor was testifying under oath, she couldn't say affirmatively, definitively, the teacher did not tell us that. She says, I'm in and out of the room. Nothing like that struck me as oh my gosh, that's a big deal. So she doesn't remember. And so, she can't say they weren't told. That's also, I think, why it's ridiculous to say we opened our files and therefore, because you didn't come look at them again, that absolves us of any of this, because what's looking at your file going to tell me about something that you didn't document? If you didn't take notes on this meeting, if you didn't transcribe it or video or audio record it, then how do I know what she did or didn't tell you?
It sounds like there were some notes. I think.
I don't know. I was telling Tanya after we wrapped yesterday that I've had cases, specifically Denton County prosecutors are really good about this. I have had prosecutors where, leading up to trial, every time they talk to a witness, I get an email, I get a PDF of their literal handwritten notes on a legal pad, and it is witness so-and-so, and it's their handwritten notes while they're talking. And I've had other prosecutors where they won't talk to a witness without another prosecutor and or a district attorney's office investigator in the room, and they're taking notes. That way, I can engage in questions and Tanya can be the one taking notes. But,
And that creates a better system of justice, because the idea of justice is not, because the old way used to be just about winning and getting convictions, and that didn't necessarily lead to justice.
No.
It led to a lot of wrongful convictions. We saw that with issues with eyewitness testimony. We saw that with lineups. I remember early in my career, as they were beginning to change the way that they did lineups, they would do the what's called double blind, where the person that is actually doing the lineup for the witness doesn't know who the suspect is. Because what was happening in the old days is the detective would basically, you'd have 6 pictures, and you'd have one picture that looked substantially different than the others, and then the detective would be like wink wink, nod nod, and so you would end up with these horrific wrongful convictions. DNA in some cases would later prove that the person didn't do it. Then you had other cases with eyewitness testimony where because of the lack of disclosure, all these things would happen, and that's the reason behind these changes in the law.
Well, going back to the original Michael Morton case, it was witness testimony that was withheld. In Michael Morton's case, Michael Morton's son told his grandmother, so the victim of the murder told the victim's mother that dad wasn't home. And the mother told that to the police. It was in the DA's file, and that was never given to the defense, something that put him not being there. And then, of course, DNA also excluded him.
And I think there was something else that was said in that case, and I wish I had done a little more research on it before, but something else was not told to them about something that was seen, like maybe a person, like a potential suspect. There were really important things that did not get disclosed that could have made the difference, a huge difference in whether or not Michael Morton is convicted. And of course, it's later proven that he didn't do it.
And of course, what is justice? Convicting a person isn't justice. Convicting the right person is justice for us as a society, for the victims, their family. I mean, we should all want the right person to be convicted. It's kind of like body cam. More transparency is always a good thing. There was some pushback early on from officers, from prosecutors against body cam, but at the end of the day, body cam on an officer protects the officer from being wrongfully accused of something as much as it does from the suspect or the defendant or the accused from being wrongfully treated. If we had a change in the law that required every witness interview done by a prosecutor or any agent of the state to be recorded and turned over to the defense, look, I mean, don't get me wrong, it would be a mountain of extra work. But then we wouldn't have these questions of, well, does anybody remember her saying South Side?
Are the notes accurate? All that stuff. It would just be what it is.
It would just be what it is. And it looks like our hearing is just about to start. Everybody just rose.
I'm handing you Defendant's Exhibit A. I did not file it because with the filing system, and it is our defense strategy, it's what you asked for. I would just ask, I know
It'll
you'll
be
have
sealed.
to file it, but you ask that it be sealed after you.
Yeah, it'll be sealed.
Thank you.
And you had your notes, Ms. Mitchell?
The record reflects that I'm tendering to the court my notes, all of my notes. Tendering to the court my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th. At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th, is when I started pulling the witness interviews with the Rangers that I reviewed her actual testimony to the Rangers. So the position that I should have had an epiphany on December the 10th when we interviewed her in anticipation of trial is misplaced, and I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th when she reviewed it.
Okay. Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So, as the court will see from what's been tendered as far as our defensive strategy, this situation did have a significant effect on the strategy from voir dire all the way through, and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this. Under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but you know, if you're making your motion for mistrial, I will tell you I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of a very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe the location that she placed, she's from probably in the neighborhood of 100 yards away, looking toward the south end of the building, and she puts, I believe she marked in a general area south of the building, the casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Noni Flores, testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again.
Yes, Your Honor. In addition, can I just, so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides that we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the only.
Yeah, I'm going to deny the motion for mistrial over your objection, obviously, and I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent, and I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I am going to do under Heath is I'm going to exclude her testimony.
We have just before you do that, really, I just want to know we have a response to if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury, and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony. One of the things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, Your Honor. It is not, because I guess my concern would be if we excluded it now and they haven't had an opportunity for.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got a little afraid. I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a state's response to the defendant's motion to exclude the testimony of witnesses SH in anticipation of their motion. So I just want to file that with the court for the court's consideration. If you could file stamp this copy too.
Okay, well,
And that's my copy.
Yeah.
The first copy's for the judge. I'm sorry.
okay, thank you.
I just want to file stamp copy.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion. Did you file a written? Did you file something?
No, no. Your
Okay, okay.
This is just anticipation of an oral motion to
Okay.
exclude, Your Honor.
Okay.
So, I don't know, Your Honor, can we confer as to possible remedies and see if we can come up with a solution? Would the court be open to that?
I mean,
Or no?
if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, well, if you want to just go back to my office, I'll stay here, and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's.
Or you can go, actually you can go to the jury room if you want to, because nobody's there. But I'm assuming that contemplates conferring that everybody goes, the state joins you. Okay. That's fine. All right, well, y'all let me know. We'll be in recess till you come back.
Okay. Well, he started that hearing off basically saying no dice on the mistrial.
Yeah. So, based on what he had initially said yesterday, that we have a hearing, put on more witnesses, we had thought that the state might call more witnesses to say, oh, and so was also in that meeting, and now they're going to say what they did or didn't hear, and that we might actually have kind of a full-blown hearing. It sounds like there probably wasn't other witnesses that were in existence, and both sides then made what are called in camera. So in camera means that they take directly to the judge something, a filing, whatever. The general rule is neither side can talk to the judge directly without the other side there. And the idea for that is, justice, you don't want one side.
It's called ex parte.
Exactly. There you go, ex parte. So, you don't want the judge, somebody whispering in the judge's ear and the other side didn't get to say, wait a minute, that's actually not true. So that's the general rule. However, there are times where you allow for an ex parte, a direct to the judge. So you say, Judge, here are documents that I don't want the other side to see. You know, what the defense disclosed was an entire briefing on here's what our defense strategy is, and here's how this affects our defense strategy. Well, obviously, it wouldn't make any sense to require that to be seen by the prosecution, because, you know, so you allow for that direct. So both sides made direct submissions to him in camera. They each had kind of put together their filings, and he had already read a lot of that before he even came in. And yeah, right off the bat, look, I'm not going to grant a mistrial. So before we started this, I said there were two options. There's a mistrial, and there's he could exclude the evidence under, and I didn't say Heath, but Heath is the big case that changed the law in 2024, and I guess we could talk more about that.
Yeah, walk people through Heath, what that case was, what it did, and it's a fresh ruling.
It's 2024, and it was a big deal. It is a big deal. It was a big change. So prior to Heath, the law in Texas was to exclude evidence, you had to have a showing of bad faith. You had to show that the prosecutor back there was, you know, I know what I'm doing.
It's malicious.
It's malicious. It's intentional. So when you heard the judge say, I make a finding that it's not intentional, that at best, and then he said actually at worst it was negligent.
Yeah.
You know, what he's saying here is, look, I don't find, and I think this is what my feeling was too, is I didn't see anything that made it really clear that this is a, you know, he's not the guy.
It didn't feel like a
kind
gotcha
of,
to me.
Yeah. It wasn't huge. It was important, and it's definitely important to the defense's entire strategy, but it wasn't such an obvious thing that it had to be intentional. And so prior to Heath, you could not exclude evidence unless it was intentional. And so what Heath said was a couple of things. One, it doesn't have to be intentional. The judge has discretion. They're not required to exclude evidence just because there's an unintentional violation, but they can. And two, in the Heath case, the state was arguing, because in that case, the prosecution hadn't gotten evidence turned over to them from the police, you know, the police department. So the police officer hadn't turned over certain evidence, and the prosecutor then obviously didn't turn it over to the defense. And the prosecution in Heath argued, we can't be held responsible for what the police don't give us. And of course, the court said, no. It doesn't say the DA's office. It says the state. And the state is not just, you know, a euphemism for a prosecutor. It is the prosecutor's office and all the agents within the police department, the sheriff's department, you know, et cetera, et cetera. So Heath was two big changes. It's everybody. It doesn't matter if you don't have the evidence. If somebody in your control has the evidence, then you're responsible for it. But the big one is that you don't have to find a showing of bad faith.
Right, and so, but it gives the judge kind of a remedy here.
Exactly, because the problem was prior to Heath, you either had to go mistrial or nothing. You know, you can't exclude the testimony. You don't have that power. And so, you know, the defense could sit there and say, you got to be kidding me. So they can just violate the law left and right, and there's nothing we can do, you know, as long as the judge isn't willing to grant a mistrial. So Heath, I think a lot of prosecutors' offices really hate Heath, but I think Heath is a really common sense remedy. It is, look, it doesn't require the judge to do it, but if the judge thinks it needs to be done, the judge has discretion to do that. To exclude evidence. So in the Heath case, it was, I think, a 911 call that had never been disclosed. In this instance, it's going to be the testimony of the witness. Although, and this is what we were talking about beforehand, what's thorny about this is not just a 911 call that the state doesn't get to put in because they didn't turn it over. This is a witness who's already testified. So how do you exclude that? Well, you tell the jury to, you know, not think about the elephant in the room, you know, to forget the things they heard. And so that's why now we're all talking about, can we craft a remedy The judge was talking about, he had already kind of thought what the defense was thinking of allowing them the ability to put in the prior statement she made to the ranger. So it's going to be interesting to see how this turns out.
Yeah, I don't know exactly what the judge. I mean, obviously he's not going to grant a mistrial, but sort of how the remedy gets crafted, I think, is what we're waiting to see. Seems like that's what the discussion is at this point.
You know, and the judge said something that I think a lot of good judges say and feel a lot of the time is, look, if both parties can agree to something, then who am I to stand in the way of that? You know, if you know, the prosecutors have a duty to you know, represent the state of Texas, and the defense has a duty to represent their client's interests. And if both of those representatives agree on something, then the judge says, okay, I'm an umpire, I'm not a player in the game. If that's what you guys want to do, fine. But it you know, I would be surprised if they can reach an agreement, especially when what the defense was already asking for, the judge has already said, yeah, that's what I was already going to do. So if I'm the defense, I'm thinking, well, unless the state is willing to do something even better than that, why would I agree? I'm already going to get what we wanted, which I think makes sense, because what Nika LaHood was trying to say is, yeah, if you just exclude her testimony, none of the context comes in. This is exactly what you were saying. The jury didn't get to hear
all this discussion,
all
background
this.
about,
Yeah, that this was never said before, that this was not disclosed, that she had told the DA. So, you know, none of that comes in. But if they get to hear the entire statement, they get a little bit more of a, oh, I see why this was a problem. And then the judge says, and now I exclude all her testimony. It doesn't seem like a, wait a minute, they're hiding things from us. They are more likely to come to the conclusion of, oh, something was wrong. I understand why this witness is excluded. And I think it makes it a lot more likely then that they can actually disregard her testimony, because they understand there's a reason for it, not just some legal technicality.
Yeah, and I was looking up the Heath case. So what it was is in 2016, there was a man named Dwayne Heath. He got indicted for injury to a child, and he had requested discovery from prosecutors, and there was a 911 call recording that the police had since the incident, and it's according to what I'm reading, it was disclosed only 6 days before the scheduled trial date in 2018. So his attorney moved to suppress the call, citing late disclosure. Trial court agreed, excluded the evidence, state appealed, and which led to this kind of really important Court of Criminal Appeals decision.
Change. Yeah, big change.
You know, the Court of Criminal Appeals in a lot of ways has been, I don't know, would you some forward, I mean, because this is, I don't know, but there's issues. I mean, I don't know, I mean, no court is perfect.
Yeah, no court is perfect. The Texas Court of Criminal Appeals is definitely a conservative court. It is definitely, look, I'm a defense attorney. I think, and pretty much all defense attorneys think, that they are very prosecution friendly. But with that said, prosecutors hate Heath. They do. They hate Heath. And
they could have easily gone the other way.
They could have easily gone the other way. And so, you know, it is unfair to say that they are, you know, a rubber stamp for the prosecution. They're not. You know, their decisions on Morton, their decision in Heath, upset a lot of prosecutors. So they're a fair court. I think they lean prosecution friendly, and they, you know, Texas is a conservative state. They are a conservative court. You know, a little more law and order, a little farther to the right.
But we have had some important changes in the law that do place beyond that court decision. We've had some important changes in the law that have placed additional responsibilities on prosecutors and on police to disclose evidence. And you know, we were talking about body cams and dash cams and stuff. I mean, you know, when I started I'm gonna date myself again here. I started as a police reporter. My first real police reporting job was in Abilene, Texas, back in the mid-'90s. I was a newspaper reporter, and you know, dash cams, body cams, none of that stuff existed.
Yeah.
And it wasn't until you know, I was pretty far into my career when dash cams came about, and you know, when you would have a police shooting or something happen, or someone would get arrested, there was not this sort of more independent arbiter of what actually happened.
Yep.
And of course, it's not just body cams, it's surveillance cameras, it's cell phones. There's so much, and that doesn't mean that any of those things are perfect, right? Because some of it depends on the camera angle and
Yep.
all those things. But in general, I think that overall, with obviously there's always exception, but in general, I think that the system is a lot better than it used to be.
Oh yeah. Look, the system has gotten a ton better. The Michael Morton Act was the first, monumental shift towards fairness in Texas criminal justice system. It really was seismic. I think Heath is too, and so having another way you can talk about Michael Morton is an open file policy. Having an open file policy is good. It's good for justice. It's good for fairness. And you might be sitting there thinking, how could it be that evidence doesn't get turned over? And the reality is, the criminal justice system is inefficient and sloppy. Sometimes it's the detective goes on paternity leave or leaves the office or gets sick and it's just sitting in their file somewhere. Sometimes it's they're understaffed and overworked and they don't think about it. Sometimes it's just they're not very, and this is a lot of the time, technologically savvy. And so it's on a legal pad somewhere, not in a computer, not in a way that can be turned over. I can't count the number of times in my career where 2 days before trial, 3 days before trial, the prosecutor calls me and says, I hate to do this to you, but I just got this big old file from the detective. Here you go. And it's, dozens, hundreds, thousands of pages, whatever it is. That happens. And sometimes it feels intentional, and sometimes it feels like an oversight, and sometimes it's new evidence. Something happened that made us go investigate further, and now we found this additional piece of evidence. So there's a lot of ways these things can kind of fall through the cracks. And what we're seeing here, witness interviews in preparation of trial, it's a really good example of it doesn't have to be some nefarious, intentional bad action. It can simply be an oversight. The fact that there's a lot of moving parts in this case, and the fact that and I think we got her name, Christina Mitchell is the prosecutor that testified. Miss Mitchell.
Yeah, she's the DA for Real and I might not be pronouncing that right, but I think it's Real and Uvalde.
Yeah.
Those counties.
And so she says, look, I was in and out of the room. You're doing 1,000 things, and I get that in a big case. But ideally, this is a wake-up call, not just to them, but to everybody, that we have to have better systems in place. And it's not about giving, quote, bad guys or defendants more rights. It's about trying to get this right, and getting it right is important for the victim and their family. It's important for the community. It's important for the accused and their family. It's just important.
Well, in my experience in having done these trials in the past is a lot of times you'll have prosecutors actually watching these trials, defense attorneys watching these trials and going, and it's sort of a learning lesson, like a real-time learning lesson about, ooh, I really should do this right.
Yeah. And and that's why I'm friends with a lot of really good prosecutors, and I want to be clear, you don't have an open file policy because we think you're a bad prosecutor. There's an open file policy, frankly, to protect you.
Right.
This is why you should not call up a witness with nobody around. Have a witness come in for an interview and not have a second there, not record it, not take notes. You don't want to be in a position where A, it's your word, and B, you have to trust your memory of the case to realize, oh, is this exculpatory? Is it important or not?
Well, I just want to kind of give a quick recap for those of you who have joined us and maybe weren't present when we saw some of the activity in the courtroom. So the hearing started again around 1:30. The judge very quickly said that he was not going to grant a mistrial, but then he left it up. The defense has gone off in a room to discuss kind of what remedy they want to have happen. I think, Mike, correct me if I'm wrong, he's got a couple different options. They can just exclude that testimony. They can play her statement to the Texas Rangers. Okay, we're starting to see the judge back on the bench. You see the judge back on the bench. I don't think we have sound back in the courtroom yet, but we're waiting to see what's going to happen.
Looks like the DAs are in the room.
The DAs are back in the room. And we're just kind of watching to see as things happen.
As we speak. You're welcome to verify the clerk is sealing those documents as we speak.
Thank you.
Okay, she's ready to go. So once again, we're outside the presence of the jury, and I've given counsel an opportunity to confer on potential remedies in regard to the witness. So what do y'all have to report?
Judge, we've had pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And that part we feel comfortable.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that agreement.
Yes, Your Honor. What we believe is ultimately we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she knows she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy, or in emotional impact, we would add that, and we do believe that under our 403 motion and motion in limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance. Because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children, are the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind, that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear, because I originally heard the court say, I'm willing to strike all the testimony now, but I'm also willing to entertain the defense's claim.
I want it on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute then? I'll be through.
Yeah, and I guess the yes. I think just the court understanding willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now, and like she just goes away, is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Right, you see what I mean? And so what it does is it puts us in a situation where that remedy could actually harm our client worse by...
Well, all right, well, we'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning, and then I'll make a decision on exclusion with everybody's participation after we rest and or actually she's finished with redirect and recross, whatever the case may be.
Yes, Your Honor.
But my recollection is she's on cross now.
She is.
Okay.
We left off where I was refreshing her with her statement, and then that's when this issue came up, and so I would just continue with the cross-examination.
They've passed her and she's on cross?
Yes, Your Honor.
Okay. All right, very good. All right, so 9 o'clock tomorrow with the witness, and we will proceed at that time. Thank you very much. We'll be in recess.
Okay, well, so no mistrial.
No mistrial.
And the judge they're going to do this, unring the bell, so to speak.
Yeah. So for everybody either just joining us or who's been watching but doesn't understand the exact mechanics of this. So the Heath remedy that they're talking about is you can exclude evidence that has not been timely disclosed to the defense by the prosecution, even though there's not a finding that failure to turn over timely was intentional. So judge said, I find that it's not intentional, it's at worst negligent, but I do think in my discretion under the Heath case that it is worthy of excluding her testimony. So he told both sides right off the bat, I'm ready to offer the Heath remedy, meaning you will just strike her testimony right now. If the defense had accepted that, that would have meant 9 a.m. tomorrow, that witness comes back, she takes the stand, the judge says, ladies and gentlemen, the court hereby instructs you that this witness's testimony in its entirety has been struck from the record. You are hereby admonished to disregard her testimony in its entirety completely. State, call your next witness. And, the reason the defense is not loving that is because, human nature, the jury's going to be, what in the world?
What just happened?
Yeah, and frankly, it's going to make them think more about her testimony than less.
Right.
Even though, the man in the black robe is telling them disregard. I mean, let's be honest, human beings can't do that. Don't think of the pink elephant. Well, there it is.
Exactly.
So, what the defense wants to do, what they kept talking about, unring the bell. So they want to go ahead and put her back on the stand. Don't exclude her now, and instead play the prior statement that we got to see, although we didn't get to hear it, we got to see her listen to
right.
when the jury was outside the presence. The jury doesn't know that happened. So now the defense says, we want the jury to hear that statement. We want the jury to hear exactly how different that statement was from her testimony.
Right, and this is a statement, folks, that she gave 4 days after the events at the Robb Elementary School. And I really want to emphasize that this is not saying she was lying in her testimony. I think it's highly likely, again, that memory is a funny thing. Mm-hmm. She has seen a lot of, presumably has seen coverage since then, seen that surveillance camera footage that shows the man in black with the rifle walking across the parking lot. And it's conceivable that in her mind, she saw that.
Yeah.
I think we want to think that our minds that we remember everything exactly as it occurred, but the reality is memory doesn't work like that. And there's been plenty of studies and lots of things that show that's just not the case.
Yeah, memory is
But-
not a videotape you can just reliably hit play on. Yeah.
Right. And so, but in this particular case, the defense is arguing that that Adrian Gonzales never had line of sight of the shooter, and so that testimony, that's why this is so critical to quote unquote unring the bell.
Right. Because, if I'm the defense, I'm sitting here thinking, oh my gosh, in opening statement, I got up and said, you're going to hear how he never had line of sight. You're going to hear how he was way over here and the shooter's way over there, and therefore he never had line of sight. What they're worried about is now the jury is thinking, wait a minute, you liars.
Right.
You sat there and lied to our faces and told us that we weren't going to hear it, and now we've heard it, and they lose all credibility. And for the defense, earning credibility is so important because they're the defense, they're the attorneys for the quote unquote bad guy. So they want to be able to show we didn't lie to you. This is, whether it's a lie or it's a faulty memory or she's confused or whatever it is, it's not what she said before. And so the judge is going to let them not only play the statement, but then allow them to finish cross-examining her. So the questions that Jason Goss for the defense asked at the time, of her asking outside the presence of the jury, you didn't say that before. The Texas Ranger gave you ample opportunity. He asked you lots of follow-up questions, but you never said that. You never said that, etc. They're going to be able to make that point very clear. And then the judge is going to give the state a chance to redirect her. I'm going to guess they're going to get up there and try to argue basically through questioning what you're saying is, hey, this doesn't mean you lied.
Right.
This has been really traumatic for you, and you've had nightmares about this, and you can't help but watch media coverage, and everybody in your life wants to talk to you about this day.
Right.
They're going to try to make it, hey, just because this may or may not be the case doesn't mean she's a liar.
Right. It's a very human thing.
Exactly.
And
I think that makes sense to let them do that.
She was an elementary school teacher, and again, I found her testimony to be really compelling. And do you think they can unring the bell?
I think it's what they have to do. They have to try. It's going to depend on how good that cross is. I think it's possible. If they can walk the tightrope, right? You don't want to beat up on the sweet elementary school teacher by any stretch, but if he can effectively, gently show that this is night and day different from what she said 4 days after the incident, and that nice Texas Ranger gave her ample opportunity to remember everything and she never said that, and this is really different, I think they can possibly unring the bell. What's interesting to me is, and I think the defense has clearly thought this through, they kept saying for the record. The record, we all know there's a court reporter taking down the record, but when lawyers talk about the record, they're talking about for the appeals court.
Right.
Because appeals courts, when I said the CCA, the Texas Court of Criminal Appeals, tends to be prosecution friendly, the CCA is very apt to saying the defense waived an argument, they waived their remedy. What Jason Goss explicitly said is, I don't want the appellate court to say, because I'm not accepting the Heath remedy now, that I am waiving it, and that how can I later still argue that there should have been a mistrial. And so he's trying to walk that tightrope and be very clear that he wants the Heath remedy. He just thinks that it harms his client more to accept it without trying to unring the bell. And he's trying to walk a very narrow tightrope to make sure that they give their chance. And this is what makes defense work so difficult. You're trying to give your client the best chance to win at trial, but you're also thinking down the road to preserve error. And that is a delicate balance of, I got to make the best choice for the moment, but I got to balance that against the best choice for a possible appeals argument down the road. And that's complicated, and that's why they had all night to think about this. They've had all morning. They're taking these little conferences because there's a lot of moving parts to this for both sides.
Are you surprised how fast the hearing went? I thought we were going to be here all afternoon.
I did too.
We're not.
I did too. No. I am surprised. I mean, I think credit to the lawyers that they clearly just didn't go home and crack open a beer and put their feet on the couch. Everybody worked through the night. I'm sure these folks need some sleep. Everybody worked on, Christina Mitchell tendered the entirety of her notes for an in-camera inspection to the judge. She clearly went through and found every single piece of paper she had on this case. Both sides, typed up their arguments, they made motions. So I think because a lot of that was done yesterday and then some of it was done this morning, the judge came to this hearing prepared, and
Right.
we didn't need to spend a whole lot of time arguing.
What do you think happens if we have another kind of thing happen? I mean, we're still early, and we were only in day one of this trial.
Yeah. I mean, guys, we're 3 witnesses into this case, and so, although Judge Harrell said, "I find that this wasn't intentional," and I think that's right, and I think in their hearts the defense would agree with that. That if it were to happen again, I don't think it's going to go well for the state.
No.
I mean, I have been in front of judges where their temper is quick and you feel like any misstep could be peril. Judge Harrell has been he smiles, he's respectful,
He seems like a really good judge.
he's just really even and
Yeah.
fair.
Yeah.
But I also, and I read up on him, he has a reputation of being fair and nice, but also you better be on your A game, you better be prepared, and you better not mess around, because he will hold you accountable. And like we said kind of before the hearing started, he is the person who initiated a very unique inquiry into prosecutorial misconduct against Ken Anderson, the then DA that handled the Michael Morton case, and
which led to
withheld
this
evidence.
change in the law.
Right.
So,
So he is known for being someone who's not to be messed with. He's nice. He doesn't act all aggressive and all that, but he's it's that walk softly, carry a big stick mentality.
Right.
He will hit you with the stick if you make him.
Exactly. Yeah, I kind of think that if there's something else they haven't turned over, they better do it.
For them, I hope they're looking at their file carefully.
Well, and we're at a late date to be doing it too. I would hate to be them if they find something else. Okay, folks, what we're going to do is we're going to wrap it up. So let me kind of give the rundown of where things stand. The jury will be back tomorrow at 9 a.m. The witness, the teacher who was on the stand that led to this issue that arose where there was a conflict in the testimony that she had the statement that she had originally given to the Texas Ranger, and then what she said in court, which prompted this whole thing that we saw this afternoon. The judge has he's declined to making a mistrial. He has, but they're going to do this remedy where they're going to put her back on the stand. They're going to play her statement to the Texas Ranger. Then the defense is going to cross-examine her on it, and then the state's going to do redirect. And then it sounds like what will probably happen at the conclusion of that is then the judge will throw out her testimony, and then the trial will.
I don't know. So
maybe.
So what happened? It was interesting because Judge Harrell did say, "Look, if you're not taking Heath now, I'm not saying I won't give it to you, but things could change."
Right.
And even Jason Goss said, "Look, we reserve the right. Maybe we develop other things in her cross-examination that help us, and now we don't want it struck." So it is going to be very interesting. I think more likely than not, they're going to want to strike her testimony, because I think they probably unring the bell to a reasonable extent. I doubt, look, I don't think this poor teacher is some bad actor who's, out to lie. It would be pretty surprising if they get some earth-shattering thing. But if they did, then I think the defense says, forget Heath, we're good. We want this testimony in because it helps us. If that doesn't happen, then I think the defense re-urges and asks for a Heath exclusion. But then again, the judge could agree or disagree then, because there's going to be a lot of things, a lot of plates spinning. So we'll see.
Okay, folks, I am going to wrap it up. I will be back tomorrow morning. we'll probably start the live stream. I think we'll start talking around 8:30. We'll have Rebecca back, and I'll have a different legal expert. Mike has been amazing. He was with us Monday and then yesterday, and I was very glad that I had you scheduled for today because it became clear that it was very important to have someone who had really been with me as that testimony was happening yesterday. Anyway, y'all, thank you for joining us, and I will be back tomorrow morning.